This morning in Legal Logic, a decision was made last week that may change the amount of privacy you have when using your cell phone. Attorney Brian Cuna joins us to talk about the decision the Supreme Court made last week, stopping the government from tracking your data, such as calls, texts, or emails. How are you, Brian?
Good morning, Will.
Thanks for coming in.
Thank you.
Look, we are on our cell phones all the time, right? You're texting, you're
400 million of them.
400 million. That's insane.
Yep.
So 400 million people are on their cell phones all the time. A lot of times.
400 million cell phones.
Right. You have private conversations with folks. And so explain to us how this is all going to kind of like work.
Well, cell phone technology is so precise now that they can track what cell tower your cell phone is connecting up to. And in that way, they can tell where you are almost as well as a GPS device.
Yeah, I think it's down to like 50 feet or something like that. I think that's the distance.
Really close. Yeah. Okay? And so last Friday, the United States Supreme Court had a case involving this guy named Carpenter, who was a criminal in Detroit, and believe it or not, he actually was stealing cell phones.
There you go.
Yeah, he was stealing, the armed robbery, stealing cell phones from Radio Shacks, and he was like the getaway driver. And the government went without a warrant and got his cell phone records. And through those cell phone records, well, he's stealing cell phones, by the way, they were able to track him and through the cell towers and know where he was, and they put him at the scene of all of these different robberies at the different locations.
Right.
And they used that to convict him. And he got 116 years in prison. Wow. So it was appealed through the different courts, and all the other courts said it was okay for the government to collect these records without a warrant. However, when it got to the Supreme Court last Friday, John Roberts, in an interesting decision, said privacy rights under the Fourth Amendment outweigh the governmental's interest without a warrant in getting these records.
So now, for the average person who's doing nothing wrong on a daily basis, will this really still even affect them?
This is what Roberts said. Roberts said that these things are so prolific that they can, you know, where they're going to church, when they're at home at night, what religions they're participating in, their sexual connections, all of that thing. And he said that that's just so prolific today in today's digital society that warrants protection, and we're not going to be, and you can't, the government can't, without a warrant, probable cause that a crime is being committed, get those records.
Now, are there any exceptions to this?
There are exceptions, correct. That's a very good question. For example, if there's a child abduction, or if there's a bomb threat, or there's a crime in commission or about to be committed. Under those kinds of exceptions, Roberts said the government in those cases does not need a warrant. It's an exception. It's an emergency. We will allow it.
Is this going to expand to people's computers or anything else, or is it just cell phones?
Another great question.
Thank you. All right, we're 2 for 2.
2 for 2. The dissent, 110 pages. It was 5-4 decision. What Alito said is that this is going to lead to a blizzard of litigation. Okay, they said that this is a bad decision because the next thing that's going to come up is, does it apply to emails? Does it apply to bank records? Does it apply to other kinds of telephonic digital communications? And we'll see.
We'll have to wait and see. All right, thanks so much, Brian.
But for now,
just your cell phone.
Your privacy is protected.
Got it. All right, thanks so much. And for more legal advice, you can check out previous topics that we have covered, and there's been a bunch, roadshow.com, and click on the Legal Logic channel.